Call.
Thank you, Chair. Good morning to you both. My first question is to the Migrant Worker Centre. The Australian Nursing and Midwifery Federation submitted that the government should consider, in addition to the existing offence, an aggravated offence which would result in harsher penalties where it is determined that a victim of wage theft was exploited as a result of a vulnerability, which could be lack of English language proficiency, migrant status, age, disability, or similar characteristics. Now, notwithstanding the fact that the existing offence hasn't been used yet, would such an aggravated offence be helpful in discouraging exploitation of Australian workers born overseas, in your opinion?
It's not something that we've considered, Senator. Thank you for the question. And it's something that would ultimately depend on the final framework of how that was built. But I think the ANMF have made some good points about that. And there are obvious intersections between people's specific, the nature of the worker themselves about their vulnerability to wage theft and other exploitation. So making sure that people are cognizant and employers are cognizant of that and take extra care with those workers is an important thing. But again, key to that, we say one of the very ultimate vulnerabilities of many migrant workers is their temporary visa and their unwillingness to kind of jeopardise some of those pathways.
Yeah, thank you. And just to ACCI, on the safe harbour provisions, does ACCI have any data on how many businesses have made disclosures under these provisions and, you know, what happened as a result of those disclosures? Because I'm particularly interested in what the Fair Work Ombudsman submitted around the safe harbour provisions where it only protects businesses from criminal prosecution and that the Ombudsman can still take civil enforcement against them. If a business comes forward voluntarily to disclose underpayments, but the disclosure can then be used to pursue civil action against them, does ACCI think this reduces the likelihood that businesses will use the safe harbour provisions in the first place?
Thank you, Senator. That's an excellent question. And to answer it, we don't have any data on that specific question. And I could only refer you back to what the Fair Work Ombudsman has said. Of course, I think there is to some extent it's easy to anticipate that there will be some businesses who might be discouraged from using that safe harbour provision on the basis they're still exposed to serious contravention penalties, which could be up to over $4 million essentially. So there is that concern there. But I do think that a business where they discover an underpayment, they take steps generally in our experience to rectify that underpayment straight away. We will advise employer to go to the flow in the event that it is a significant underpayment. But if it is a small business and there's been an underpayment, we advise those employers to rectify it straight away, explain to the employees how it's occurred, explain to them what rectification is, and explain to them what steps are put in place to prevent that from occurring again.
Yeah, and just further on that, would you not see that as there being a further disincentive for a business that has identified wage theft as having occurred if the Fair Work Ombudsman does not agree to enter into a corporation agreement, that it may become subject to criminal investigation under 327A, Section 327A1, and have incriminated itself when attempting to make a good faith disclosure?
Look, that's a difficult question to answer, Senator. I think at the end of the day, if an employer has engaged in intentional underpayment as prescribed or envisaged by Section 3271A1, then I'm not certain that that would be a relevant necessarily consideration for that business, and certainly not small business. Now, look, if it is a one-off late payment, the expectation would be, although technically the legislation doesn't say this, the FOI will tell you that that's not necessarily going to result in a criminal prosecution. So I don't think it's necessarily a live issue in the context of small business. There is a capacity for the FOIA, obviously, to not enter into a cooperation agreement, and there's certain quite strict conditions around which those cooperation agreements are entered into. I think that's, in the context of small business, it's more a case that that cooperation agreement is aimed at larger businesses where there has been a significant scale of underpayment, rather than necessarily that at the small business level.
Yes, and I mean, to your point, the point you were making to the chair's question earlier around the one-off late payments that may be made, but that could potentially result in being considered a criminal act. Now, we know that a criminal conviction for late payments would still require proof beyond reasonable doubt that the employer, deliberately intended not to pay the worker on time. So it would not capture, genuine mistakes or things beyond your control. Would you say that, do you believe employers should be able to deliberately, not accidentally, miss paydays and get away with it?
I believe that an employer that intentionally or deliberately doesn't pay an employee on or before the date that that payment is due, if it occurs in circumstances where that's done knowingly and it's done for circumstances beyond the employer's control, I don't feel that they should be penalised. I don't think that any employer who deliberately decides to delay the payment to an employee for reasons other than something that's beyond their control, I don't think that should be is acceptable conduct, and that is likely to result in a civil prosecution potentially under the Act where that behaviour is occurring. But if it's beyond their control and it's a one-off, then I think that that should not result in any type of criminal prosecution or consideration.
Thank you. Thank you, Chair. I'll put the rest of the questions on notice, being mindful of time.